While policy discussions and enforcement strategies may continue to evolve, the fundamental principles governing denaturalization, materiality, intent, evidence, and judicial oversight remain constant. Understanding these principles allows individuals to interpret developments in immigration policy with greater clarity and confidence, reducing unnecessary fear while maintaining awareness of how the system operates in practice. The question of whether the United States government can strip away naturalized citizenship is one that sits at the intersection of law, policy, and public perception, and it often generates more fear than clarity because of how it is discussed online. At its core, denaturalization is not a new concept, nor is it a tool used casually or frequently. It exists as a legal mechanism reserved for specific and serious circumstances where citizenship was obtained through fraud, concealment of material facts, or intentional misrepresentation during the immigration and naturalization process. What makes this topic particularly sensitive is not just the legal authority behind it, but the way headlines, social media commentary, and incomplete interpretations of policy statements amplify uncertainty. When people hear phrases like denaturalization efforts or government review, it can sound as though there is a sweeping, indiscriminate campaign targeting naturalized citizens. However, the reality is far more constrained and grounded in due process. Every denaturalization case must pass through the federal court system, where the government carries the burden of proof. This means evidence must be presented, examined, and evaluated by a judge, and the standard required is intentionally high. Citizenship is not revoked based on suspicion, administrative review, or minor inconsistencies. It requires a demonstration that the individual's original eligibility for citizenship was fundamentally compromised by deliberate deception. This distinction is critical because it separates lawful enforcement from the perception of arbitrary action. While government agencies may issue internal guidance or policy memos that outline priorities or referral thresholds, those documents do not themselves strip citizenship or bypass judicial oversight. Instead, they serve as internal coordination tools that help identify cases that may warrant further investigation. The existence of such processes does not equate to widespread enforcement. Rather, it reflects an ongoing system designed to address cases where serious violations may have occurred. Understanding this framework helps reduce confusion and allows individuals to interpret headlines within the proper legal context rather than reacting to isolated statements or exaggerated claims. To fully grasp why denaturalization cases occur, it is essential to examine the types of situations that typically trigger them and the patterns that emerge from publicly available case data. Historically and in recent years, the cases pursued by the Department of Justice have involved individuals who were already implicated in significant criminal activity, such as fraud schemes, national security concerns, or other serious offenses that, upon investigation, revealed inconsistencies or false statements in their immigration records. In many instances, denaturalization is not the starting point of an investigation, but rather a secondary outcome discovered during broader criminal proceedings. For example, when an individual is under investigation for financial fraud, trafficking, or organized illegal activity, law enforcement agencies may uncover discrepancies between their criminal history and what was disclosed during their naturalization process. These discrepancies, if material, can form the basis for a denaturalization case. This pattern is important because it demonstrates that the government is not randomly auditing naturalized citizens en masse. Instead, cases tend to arise organically from existing investigations where evidence of fraud is uncovered. Another key factor is the concept of materiality, which plays a central role in determining whether a misrepresentation is legally significant. A material misrepresentation is one that would have had the potential to affect the outcome of the naturalization decision had the truth been known at the time. This is a high standard, and it ensures that only serious violations are actionable. Minor omissions, misunderstandings, or trivial errors that would not have impacted eligibility do not typically meet this threshold. As a result, the cases that proceed to court often involve clear evidence of intentional deception related to eligibility criteria such as criminal history, identity, marital status, or residency requirements. This selective nature of enforcement underscores that denaturalization is not a tool used for routine corrections or minor infractions, but rather a targeted legal remedy for addressing cases where the integrity of the naturalization process may have been compromised in a significant way. By examining the types of cases pursued and the legal standards applied, it becomes evident that enforcement is focused, evidence-driven, and constrained by judicial oversight rather than being broad or indiscriminate. For naturalized citizens and those considering citizenship, the most important takeaway is not fear, but awareness of how the system actually operates and what protections are in place. The legal safeguards surrounding citizenship are designed to ensure that revocation cannot occur without substantial justification, due process, and court involvement. This means that citizenship, once granted, is not easily taken away and is generally stable unless there is compelling evidence of fraud that goes to the heart of the original application. Public concern often arises from misunderstandings about policy announcements, which can sound more expansive in tone than they are in practice. Statements made by officials may emphasize the seriousness of fraud or reaffirm the government's commitment to enforcing the law, but they do not automatically translate into large-scale actions affecting millions of people. Instead, the operational reality involves limited resources, case-by-case evaluation, and a legal process that requires time, documentation, and prosecutorial effort. It is also important to recognize that the government prioritizes cases where the alleged misconduct is severe and demonstrable rather than attempting to revisit every naturalization case across the country. This practical limitation, combined with legal constraints, naturally focuses enforcement on a relatively small subset of individuals whose cases meet the necessary criteria. For the vast majority of naturalized citizens who have followed the rules, provided accurate information, and obtained citizenship in good faith, there is no indication that they are being targeted or subject to routine review for minor issues. The system is structured to address fraud where it is proven, not to retroactively scrutinize every application without cause. By understanding both the legal framework and the actual patterns of enforcement, it becomes clear that denaturalization is a rare and exceptional outcome, rather than a common or widespread occurrence. This perspective helps replace uncertainty with informed awareness, allowing individuals to view the issue through the lens of law and evidence rather than speculation or fear-driven narratives. Building on the legal framework and real-world patterns of denaturalization, it becomes even more important to understand how these cases are actually initiated, processed, and ultimately decided within the United States judicial system. Denaturalization is not an automatic administrative action that can be triggered by a single agency or a simple internal review. Instead, it is the result of a multi-step process involving coordination between immigration authorities, investigative agencies, and federal prosecutors, all operating under strict evidentiary and procedural standards. In practice, a case often begins when irregularities are identified during a background check, a criminal investigation, or a review of immigration records. These irregularities might include discrepancies in identity, undisclosed criminal history, or inconsistencies in marital or residency claims. Once such issues are flagged, they are typically referred for further investigation rather than immediate legal action. At this stage, agencies like USCIS may compile documentation, verify records, and assess whether the issue could potentially meet the threshold for material misrepresentation. If the findings suggest that a serious violation may have occurred, the matter can then be referred to the Department of Justice, where federal attorneys evaluate whether to file a civil denaturalization case in federal court. This evaluation is not taken lightly, as each case requires significant resources, legal justification, and a high likelihood of success. Prosecutors must demonstrate not only that a misrepresentation occurred, but also that it was intentional and material to the original grant of citizenship. Once a case is filed, it proceeds through the federal court system where the defendant is entitled to full due process, including the right to legal representation, the opportunity to present evidence, and the ability to challenge the government's claims. A federal judge ultimately determines the outcome based on the evidence presented by both sides. This layered process ensures that denaturalization is not arbitrary, but rather a structured legal proceeding governed by established rules of evidence and constitutional protections. It also explains why the number of cases remains relatively low compared to the total population of naturalized citizens. The time, effort, and legal burden required to pursue each case act as natural constraints on the scale of enforcement, reinforcing the idea that denaturalization is reserved for specific, well-substantiated circumstances rather than used as a broad enforcement tool. Another critical aspect to consider is the role of intent and materiality in determining whether a case qualifies for denaturalization. The legal system does not penalize simple mistakes or minor oversights that have no bearing on eligibility for citizenship. Instead, the focus is on whether an individual deliberately concealed or falsified information that would have influenced the decision to grant naturalization. For example, if an applicant failed to disclose a criminal conviction that would have disqualified them from obtaining citizenship, that omission could be considered material. On the other hand, an unintentional error, such as forgetting to list a minor traffic violation that does not affect eligibility, would not meet the same legal threshold. This distinction is fundamental because it protects individuals from losing their citizenship over inconsequential errors, while still allowing the government to act in cases where fraud undermined the integrity of the process. Courts carefully examine the intent behind the misrepresentation, the nature of the information that was withheld, and whether that information would have reasonably changed the outcome of the application. This standard ensures that denaturalization is applied in a fair and consistent manner, grounded in evidence rather than assumption. It also places a significant burden on the government to prove its case, which is why successful denaturalization cases are typically associated with clear and documented instances of fraud. The requirement to establish intent and materiality serves as a safeguard against misuse of the process and helps maintain public confidence in the stability of citizenship. Without these legal thresholds, the potential for arbitrary or unjust revocation would be much higher, which is precisely why the system is designed to be both rigorous and selective in its application. Ultimately, the broader context surrounding denaturalization highlights the balance between enforcement and protection that defines the United States immigration system. On one hand, the government has a legitimate interest in preserving the integrity of the naturalization process by addressing cases where citizenship was obtained through deception. On the other hand, it must ensure that individuals who have lawfully obtained citizenship are not subject to undue risk or uncertainty. This balance is maintained through judicial oversight, evidentiary standards, and a focus on cases involving serious misconduct. Public perception, however, often diverges from this reality due to the way information is presented in media and online discussions. Sensational headlines and incomplete summaries can create the impression that denaturalization is more widespread or unpredictable than it actually is. In reality, the available data and documented cases suggest a targeted and controlled approach, concentrated on individuals who have been involved in significant criminal activity or fraud. For naturalized citizens, this means that maintaining accurate records, being truthful during the application process, and complying with the law are the primary factors that ensure long-term security of citizenship. The system is not designed to revisit every case without cause, but rather to intervene when credible evidence of wrongdoing emerges. This approach allows the government to uphold legal standards while also protecting the rights of individuals who have followed the rules in good faith. As new policies, statements, or enforcement priorities are announced, it is important to interpret them within this established framework rather than viewing them as indicators of sweeping or indiscriminate action. By doing so, the conversation shifts from fear and speculation to clarity and understanding, which is essential for anyone trying to make sense of immigration policy in a rapidly evolving informational landscape. Another important dimension that often gets overlooked in discussions about denaturalization is the historical context and how the policy has evolved over time in response to changing legal priorities, national security concerns, and administrative capabilities. Denaturalization is not a newly created mechanism. Rather, it has existed for decades as part of the legal toolkit available to the federal government. However, its usage has fluctuated significantly depending on the era and the type of cases being prioritized. In earlier periods, denaturalization was sometimes used more broadly, including during times when national security concerns were heightened or when immigration enforcement strategies were more aggressive. Over time, however, the approach has become more refined, with a stronger emphasis on due process, judicial oversight, and the requirement of clear, material evidence of fraud. This evolution reflects a broader shift in the legal system toward balancing enforcement with individual rights, ensuring that citizenship is not treated as a temporary or easily revocable status. In the modern context, denaturalization is primarily treated as a civil legal action rather than a criminal punishment, which means it is focused on correcting cases where citizenship was improperly obtained rather than punishing individuals for unrelated conduct. This distinction is crucial because it frames denaturalization not as a penalty imposed for general wrongdoing, but as a remedy for situations where the original grant of citizenship was fundamentally flawed due to deception. As a result, the government's ability to pursue these cases is inherently tied to the availability of credible evidence that can withstand judicial scrutiny. Without such evidence, cases are unlikely to succeed, which further reinforces the selective nature of enforcement. This historical and legal evolution also explains why modern denaturalization efforts tend to be more focused and less frequent compared to what some people may assume based on isolated statements or policy discussions. The system has matured into one that prioritizes accuracy, fairness, and evidentiary strength over broad or indiscriminate application. In addition to the legal and historical framework, it is also essential to consider the practical limitations that influence how denaturalization cases are identified and pursued in real-world scenarios. Federal agencies operate with finite resources, including personnel, time, and funding, which naturally constrains the number of cases that can be actively investigated and litigated at any given time. Each denaturalization case requires extensive preparation, including document review, witness testimony, coordination between agencies, and legal analysis by experienced attorneys. These requirements mean that agencies must prioritize cases that are most likely to succeed and that involve the most significant violations. As a result, the selection process tends to favor cases where there is already a strong evidentiary foundation, often discovered through parallel criminal investigations or intelligence-led inquiries. This practical reality helps explain why denaturalization cases are not widespread, even when internal reviews or referral processes may suggest a higher potential volume of cases under consideration. The gap between internal activity and publicly filed cases is not necessarily indicative of hidden mass enforcement, but rather of the rigorous standards that must be met before a case can proceed to court. Furthermore, coordination between agencies such as USCIS, the Department of Homeland Security, and the Department of Justice introduces additional layers of review, each of which must be satisfied before legal action is taken. These procedural steps act as filters that ensure only the most substantiated cases move forward. In this sense, the system is designed not only to identify potential fraud, but also to prevent weak or unsupported cases from consuming limited judicial and prosecutorial resources. This structure reinforces the principle that denaturalization is a carefully controlled process rather than an open-ended or automatically triggered enforcement mechanism. For individuals observing from the outside, this can sometimes create the impression that little is happening, when in reality, significant behind-the-scenes evaluation is taking place before any public action is visible. Finally, when considering the broader implications of denaturalization policy, it becomes clear that public understanding plays a crucial role in shaping perceptions of risk and stability for naturalized citizens. Much of the anxiety surrounding this topic stems from incomplete information, misinterpretation of official statements, and the amplification of worst-case scenarios through social media and online commentary. In the absence of clear context, phrases like increased enforcement or policy changes can be interpreted in ways that suggest widespread targeting, even when the underlying data does not support such conclusions. This highlights the importance of relying on verified information, official records, and documented case patterns rather than speculation or isolated narratives. When examined closely, the available evidence consistently shows that denaturalization is applied in a narrow set of circumstances, typically involving serious fraud or criminal conduct that directly relates to the original acquisition of citizenship. For the vast majority of naturalized individuals who have adhered to legal requirements and provided truthful information during their applications, there is no indication that they fall within the scope of enforcement priorities. This reality underscores a key point. Citizenship, once granted through lawful means, remains one of the most stable legal statuses in the United States, protected by constitutional safeguards and reinforced by a demanding legal process that must be satisfied before any revocation can occur.